Today's presenter, Russell Jackman, is a graduate of the McGeorge School of Law, University of Pacific, and was admitted to the State Bar of California in June of 1994. He has been vice chair of the California State Bar's Law Practice Management and Technology Committee and a member since 1996. He works specifically with law offices and attorneys that need to get the most out of their legal technology and creates PowerPoint presentations for opening statements, direct examinations, and closing statements to be used in court, and can work with attorneys directly to filter their documents and images so that they have the most powerful visual presentations possible. He also works with law offices and solo attorneys to upgrade their older systems to new ones, troubleshooting existing setups, and training attorneys and staff on Microsoft programs. He is available for remote access consulting on technology-related issues, so please feel free to contact him at any time.
Hello, my name is Russell Jackman, and today we're talking about online civility and attorneys. I'm an attorney based in California, but right now I'm seeing a trend where, especially with what is going on with the coronavirus situation and what we have going on with everybody having to do things online more than they've done in the past, the level of civility and the ability to manage being online with civility is a problem is an issue across the entire United States. So what I wanted to do was have us talk a little bit about what's going on with civility in general and understand that it's a big problem that our industry faces. One of the big problems about civility, even just coming right out of the box, is that the lawyer's image itself is not really great right now. From the ABA Journal, they were talking about the fact that you have definitely problems with large cities where you have people all pressed in together, but even then you have situations where younger associates are, especially with female ones, trying to use it for a tactical advantage. But in civility, we've seen, of course, across the United States, isn't really great from persons to persons, but with lawyers themselves, things are not good. And when that image is negative towards attorneys in general, then it's going to make our profession harder to get respect from clients and from politicians and from the media and from other lawyers as well. And so lawyers in general, when they were surveyed, blamed the incivility on, a lot of times the media itself will show lawyers as being really over the top and that lawyers are always these John Grisham novel kind of standout A triple plus personality people, and they're always these Perry Masons or you have these high flung portrayals of attorneys being super media types. But in the end, I mean, more lawyers are average people, and they are people that may have studied something for a long period of time, and they've got a specialty in one profession. But that doesn't mean that they're not regular people as well, especially when they get outside of the courtroom. There is definitely a problem with inexperienced lawyers and a lack of mentoring in most states. There just isn't the kind of organized attempt by attorneys, especially in the current partnership structure that you have with a lot of law firms. It can be a real problem when you're seeing this sort of shark eating environment that they have, where managing partners are trying to get associates to drop out by overworking them and not really showing them any of the ropes. They're more interested in getting as much work out of them as they can, throwing them into as many fires as they can, and then, hoping they get the cash out of them, and then those people will leave and they don't threaten their desire, their inside track to, become partners. And then there's certainly a fuzzy line between aggressive advocacy and rudeness. And on the one hand, there's a famous quote that says, "Everybody else's lawyer is an asshole, but not mine." And if you want your attorney, obviously, to be doing as much as they can to fight for your cause and to stop at no level to make sure that you win a case. That's obviously the best possible scenario for who you want as an attorney. But clients have to have some realistic expectation of attorneys adhering to some level of civility as far as how they're pursuing this, because really you can't just have a complete scorched earth policy and say, well, my client told me to do this. I mean, you can't go and break all the rules of civility and say, well, I did that on behalf of my client. It's the only way my client would have anything, And look, clients are often a major source of where this anger comes from or where the fire comes from. But ultimately, too, it can backfire in the sense that then if you're not as aggressive for your client, you see a client that's asking you to do things above and beyond the level of any reasonable civility, that if you don't do that sort of thing, the client will become that uncivil with you. Maybe it's not a great client for you to be working with in the first place. So we'll talk about this later, but the fact that today's technology really does, there's certainly a culture now we see of people that act anonymously and how they act when they don't think people are looking. And it's pretty reprehensible. And then, of course, the country's current fractious public discourse, which, permeates politics, it permeates social media. I mean, I'm certainly guilty of it at times myself when I get into online arguments with people in some of the political groups that I'm in. And I would say this, while I certainly get into some severe arguments, I know that there are limits and there are things that you can't do, and that there's a level at which you're going beyond any sort of reasonable expectation of, well, you're just arguing a point here. And so that's one of the things we're going to talk about, is what those limits actually are. The lack of civility is a national problem. New York State Bar Association hosts an annual conference called Lessons on Ethics and Civility. The Utah State Bar has an Office of Professional Conduct, and they have an ethics hotline and an ethics school. And then Illinois created a professionalism and mentoring program with the name To Civility. And I think that stands out as one of the really interesting and significant efforts put forth by any of the states so far as not only providing an organization that is central to the idea of civility, but also providing help and organization so that people can get better. And some of the things that we just talked about on the previous slides, things like pointing people towards willing mentors and guiding younger attorneys so that they would be able to have this sort of support for learning early how to be civil. I certainly think that is one thing that does help somewhat, is if you can start civil, it's easier to stay civil. Whereas if you're going to be, basically a jerk from day one, it doesn't get much better. People don't tend to get more civil as they go through the profession. And so you've got to do what you can to lay the groundwork and the seeds to get people to be civil to start with. And we'll talk about that later too. So how prevalent is it? The Illinois Supreme Court showed that 90% of lawyers describe their colleagues as generally civil or very civil professionally, but 85% said they experienced at least one incident of uncivil or unprofessional behavior in the prior 6 months. Not a year, that's not even throughout their profession. They're saying in the last 6 months, 85%. You get 85% of people to say on a survey anything they agree in. It's a pretty stunning number. And I think what was good about Illinois is that they took these numbers very seriously in creating the Civility website that they have. And we're going to go check that out right now. So the example of civility in practice is the Civility website that Illinois created. And that their motto is they are connecting lawyers and inspiring change. And it's in conjunction with the Supreme Court Commission on Professionalism. They host what they call Future is Now conferences that that get together attorneys, both that have been in profession for a long time, plus young attorneys that are just starting out, and they allow them to interact and have a number of different seminars that help guide them towards being more civil and directing them to a better way of practicing. And that's really something that will help, not only the future generations of attorneys become more civil, but sort of as a reminder to the existing attorneys that are teaching these civility seminars that, how to get reconnected with that sort of that sort of mentality and what it takes to be, civil. Well, these definitely have different MCLE programs associated with them, so practicing attorneys can get a refresher or a reminder or even sort of a new look on what is being considered, part of a civil practice and being civil in their practice when they go to the Futures Now conferences. Illinois, the Civility also has connections with mentoring, CLE programs, and with law schools, so that they're trying to interweave themselves in every level of practice, from the beginning when students are in law school to when they're practicing and when they are continuing their legal education. They also are very strong in networking with being connected with diversity and inclusion, looking at where the future of the practices for the Illinois. They have a lot of connections with the different Illinois court associations and the other legal associations, and then even connecting themselves with national affiliates so that there can be kind of a universal structure of civility that, common practices that can be shared across the United States, raising the level of civility across the USA, which is really, because when you boil it down to it, yes, different states have different issues and the laws are a little bit different, but civility is kind of a human practice thing. You're either civil to people or you're not. You're, able to work with people and work with your clients and work with other attorneys and work with the court, or you can't. And so it's a human thing. And I think Illinois has shown a really wonderful assimilation of combining all these different factors together and all these different entities together with a common thread of civility. And it's an ongoing process, but they're working so hard trying to make sure that the things that go on in Illinois are better than what we've seen in the 2014 survey. Show that 85% of those surveyed saw something uncivil in the last 6 months. Now, I'm here in California, and we have our guideline of civility and professionalism as well, which is under Section 4, talking about attorneys' communications about the legal system should reflect civility, professional integrity, professional dignity, and respect for the legal system. Attorneys shouldn't engage in conduct that is unbecoming of a member of the bar and an officer of the court, and not just in communication with the legal system, but also with their adversary. And so things like are included is that an attorney should have respect and esteem for the civil and criminal justice systems. Now, that is not to say that everything that goes on in court or everything that's done by any judge anywhere needs to be treated with religious sort of awe and respect. I mean, they do want, there is always going to be a conflict or a challenge between people's perceptions and their First Amendment rights to say what they feel about how a government system is operating versus creating a lack of civility and a hostility level that is so unproductive that it obstructs justice and doesn't do anything for creating any kind of a positive work environment. So that's going to be always things that are going to have to be balanced and looked at. That neither is free speech so invulnerable that it allows people to create a unprofessional level of conduct. But on the other side, how far can the government go to say that what somebody is saying, especially when they're voicing a political opinion, that is something that should or even have the government even has the power to restrict. Guideline does not prohibit an attorney's good faith expression of dissent or criticism made in public or private discussion for the purpose of improving the legal system or profession. So therein we have the dichotomy of good faith expression. And that is obviously something that can be argued, but if somebody is, calling opposing counsel, names and certainly situations where there are racial or sexual discrimination being brought forth, then you have a situation that there isn't good faith and that you're not just expressing something, dissent or criticism, but you're actually using it as an attack. Attorneys should not disparage the intelligence, the integrity, the ethics, the morals, or behavior of the court or other counsel, parties, or participants when those characteristics are not at issue. Again, I've seen this letter C violated on many occasions, especially in intense negotiations before settlements are reached. It's not pleasant. It's not pretty. You're not supposed to do it according to California, yet it happens. Respecting cultural diversity, an attorney should not disparage another's personal characteristics. Again, it's horrible that people would even go to that level and expect to and not realize that is a tremendous lack of respect being issued. But it is something that does happen, unfortunately, on a not so irregular basis. An attorney should not make exaggerated, false, or misleading statements to the media while representing a party in a pending matter. And that's obviously something that, works online as well as in person, because the media that we see now, would include social media too. And so, even though this was written before social media was really as prevalent, certainly attorneys have that bent to sometimes talk about case issues in a public forum, on their Facebook page, on LinkedIn, that sort of thing, and revealing too much, or just doing it as making your social media into a bully pulpit, where you will just bash the other side and use that as a way to disparage or defame or cause some sort of controversy based on the other side, could certainly be a focal point for a claim of lack of civility. Attorneys should avoid hostile, demeaning, or humiliating words. Unfortunately, you'll get an example a little later of a friend of mine who is a mediator who will tell you that she just suffered those sort of things just recently, and it's something that doesn't go away. A lot of attorneys think that by being hostile or by being humiliating, it makes their point more salient legally, and it doesn't. I mean, in fact, it's usually a sign that a legal point is even less effective, because if it was something that you didn't need to go to that extent, in other words, if you have to go to those low levels to be hostile or demeaning or use humiliating words, your legal point is probably not all that great. It's usually a sign that you're trying to shore up for a weakness in your case. And in any event, it doesn't wind up swaying anyone. It doesn't it makes the other side matter, usually makes them want to try even harder to undercut your case, or again, get emotional, and throw those sort of things back the other way. And then it just builds up to a larger level of ugliness, which, doesn't help anyone in the administration of justice. It just becomes an argument, it becomes name calling. It's a waste of everybody's time in the end, because what you really are trying to do is trying to get down the administration of justice, not to the administration of insults. Attorneys should not create a false or misleading record of events or attribute to an opposing counsel a position not taken. In other words, lie. I mean, and some people in their level of pride will create a false narrative or a phony timeline to try to justify why they said some of these horrible, demeaning, uncivil statements in the first place. And those sort of things just make the matters worse, because instead of the other side saying, okay, well, yeah, you're right, all these things that didn't happen actually happened. No, it usually then becomes a side argument about how this uncivil language got started and so forth. And then you're not even talking anymore about the case at hand or the facts that are going to trial. You're now off on a tangent about who said this about whom, and why did they say this, and when did they say this, and this person said this first, and I was only reacting because this person was saying that. And the last thing a judge or a mediator really wants to see or have to deal with is a he said, she said, or he said, or she said argument of what is totally ancillary to the case at hand. It wastes everybody's time, costs your clients money. It doesn't lead towards the actual adjudication of the matter at hand, and winds up, creating these uncivil moments. And an attorney should agree to reasonable requests within the interests of efficiency and economy, including agreeing to a waiver of procedural formalities where appropriate. And obviously, if these are things that can be agreed upon, you can be civil enough to get that agreed upon ahead of time. It will save you a lot of time and money and hassle for your clients. Your clients will appreciate it a lot. And then, unless specifically permitted or invited by the court or authorized by law, the attorney should not correspond directly with the court regarding a case. Certainly going behind other counsel and having discussions about the case with the court that the other side doesn't know about, it's just not going to foster anything positive. And you want to be able to represent your client's case without stooping to any levels that would compromise the integrity of your client's case. And that's the whole thing. It's that is what you're doing something that has a level of professionalism to it. If it doesn't, it's in the end not going to wind up helping your case as much as you. So here's some tips on civility and the practice of law, as stated by the American Bar Association in 2018. They did sort of a survey, and then they had some results, and they gave some advice that they thought would be helpful, which is that talking to your clients about specific expectations regarding civility. And this becomes important when opposing counsel is cantankerous and difficult. And that discussion is mission critical prior to trial. I mean, you need to know that your client isn't expecting you to get down into the mud too, or at what level they know that you're going to withdraw back from that for the sake of the case, for the sake of civility and the effectiveness of your case. Don't respond in kind when you receive an email missive from opposing counsel. Stick to the law and the facts of your response. Better yet, pick up the phone, or right now Skype, or some sort of FaceTime, or cell visual thing that would allow you to even be able to see opposing counsel and see if you can talk things out. A lot of times these sort of uncivil things can come from a lack of understanding because of people's backgrounds, their cultural backgrounds, sometimes it's a language situation. You want to make sure you're not making a mistake and misinterpreting what somebody is saying or what their response is, so that you can find out before you notch things up or say something that you might regret. If opposing counsel is uncivil or unprofessional, document the behavior. Also, have a colleague join phone calls or meetings so there's a witness. The behavior, however, may cease if a second lawyer is present. But, if that means that that's what it takes to get this person to be civil, then you know what? It's probably worth it to have another person present, or at least, let them. It's not legal to record somebody without their consent, but you can let them know that you're beginning to record something from the beginning of that call, and they understand and acknowledge that they're being recorded. And that can sometimes change their behavior, because they know that if this sort of thing could come back to bite them. When discovery, meet, and confer efforts are futile, meeting in person before filing a motion to compel. Most courts will appreciate the attempt to work things out face to face. Some even require it. So you'll have to see if your jurisdiction makes you do that. But even if it's not something that's mandatory, there are times where if everybody sees face to face, there's a chance that a person will drop the bravado and the feeling of anonymousness, that the anonymity that they have through talking online to you, and actually deal with you when they see you face to face. And then if you expect opposing counsel to bully and bully counsel and witnesses during depositions, videotape the depositions. It's not, or have it recorded by cell phone or something like that. As long as both sides know that it's going on, and you do that before it starts. Having evidence of it is always going to help your case and keep from it being misinterpreted or somebody saying, well, you took something out of context or something along those lines. Keeping written records of all uncivil actions with opposing counsel, writing a memo to the file for telephone conversations are helpful. You have to report the conduct to the disciplinary committee. And a lot of times it's not the first time that they've heard this, about a particular attorney. Very rarely does someone that is so out of control, and that's who they are personally, that would be their first time that they'd ever, show display of anger. So sometimes, by bringing it up and having a record of it, it matches other records that they have, and it will look bad for the other counsel if they act out. Writing a letter to opposing counsel regarding your concerns and enclosing a copy of the standards of civility and or the rules of professional conduct. I mean, that can be a little bit passive aggressive, but at least you said your piece and you're saying that you're aware of this and that you're making the other side aware of it and that they're making them aware that you are aware of their lack of civility. You've shown them how their behavior of recent, you want to time it. If you send this out, be relatively close to when that sort of activity happens so that the other side knows and are made aware of the fact that they're not acting civil when you're trying to deal with them. And then speaking with other attorneys in your law firm, such as supervising attorney or a mentor, and asking for their advice. Again, we see how having other attorneys that you can work with, mentor of some type, so that you can quote unquote check yourself before you wreck yourself, is actually a very helpful thing to do, and sometimes could go a long way towards you avoiding any kind of misunderstanding, or that maybe you're missing something, or maybe it's you that's not being civil and the other person's trying to be civil, but you're not giving them a chance. And then setting limitations and stating consequences. In other words, if the counsel is going to keep swearing at you, then you're not going to communicate with them. You have it documented, and that you have witnesses, and that if all it's going to be is that person swearing this and swearing that at you, calling you epithets, calling you using racial terms or whatever, that this person and you cannot create a level of civil ground through that kind of communication. You'll only speak to them through written documents. And if written documents continue to be profane, then you can certainly go to the State Bar Association or to the judge in the case and have the judge take matters into their hands. If the attorney whose conduct is inappropriate being supervised by a more senior attorney, you can go to that managing partner and let them know about the inappropriate conduct. I mean, it's kind of snitching on them, but I mean, it would be good for managing partners in that instance to know that they have a loose cannon on board. If they're aware of that and it doesn't matter to them, and a lot of cases that's the case, then when you see the opposing counsels for that firm coming up, then you could maybe also report them to State Bar and let them know that this is something the whole firm is engaged in, not just one attorney. If the counsel's behavior is uncivil after repeated warnings, you could walk out of a settlement discussion deposition. I've been very close to that on a couple of times myself. It is a negotiating tactic to just show that there's a line at which you're not going to go over. And if someone continues to cross that line, you just can't continue on. And especially if your client knows that you have this specific limit, you've informed your client that if this conversation gets to this level, that we are prepared to walk out of the negotiation, settlement, or deposition. We just will not cooperate. And it's okay with the client, and they understand why you're doing that. Then that's a tactic that, with enough evidence behind you that you can say, this is why I had to do it. This is the warnings that the other side had. They knew that if they acted in this manner, and continued to, that I wouldn't continue working with them. If that was well notified to them, and they still acted that way. A court's not going to see that you're the one that's uncivil. Now, if certain things like violating the deposition rules and insisting that all future depositions be videotaped is always kind of a good fail-safe to make sure if you've got someone that you're working with that you think is uncivil, because a lot of times people's behaviors change a lot once they know they're on camera. And if opposing counsel persists, then you are going to have to bring attention to the judge or report them to the State Bar Disciplinary Committee. It just, you have to take some sort of stand. And as I said, very rarely is there a situation where someone who is that uncivil, that's the only time they've ever acted uncivil to anyone is when they've acted uncivilly to you. And so there may be more to the iceberg than just the tip. It may go very deep, and the State Bar Association may really want to know that this person acts in this fashion and should be disciplined for repeated acts of incivility. So I'd like to play a clip now from a mediator friend of mine named Joanne Bobiak. She has some interesting stories and advice to give over her experience as a mediator. So here we go.
Hello, my name is Russell Jackman, and I am here with mediator in Marin County, Joanne Bobiak. And Joanne has had a lot of experience with working with adverse counsel, and she has a few things that she'd like to tell those of you who are listening to the presentation today.
Hi, I'm a member of the California State Bar as well as being a trained mediator. I just wanted to talk to you about some of my experiences. They're few and far between that have to do with adversarial behavior that kind of sinks to a level that is not appropriate. I think that no matter where you stand on the political spectrum of things, one of my past experiences has carried great meaning for me. At the time that Anita Hill was testifying, and Judge Clarence Thomas, Chief Justice in the United States Supreme Court, was involved in a controversy involving Professor Anita Hill, who was an attorney and a law professor. Justice Thomas came to Oklahoma. I happened to be there. I was a law student at University of Tulsa College of Law. And I was a stranger in Oklahoma, but I did get a very good education there. Justice Thomas, no matter where you're aligned on the scale, did leave an important message the day that he visited the University of Tulsa College of Law. And his comment was, civility is extremely important in your dealings as a lawyer. And we were all law students, and we took his message to heart, and I have carried that message with me. Don't sink into the mud, or you'll be covered with mud. Always try to take the high road, and please share that sentiment with your clients. Your behavior in court is oftentimes something that will influence the judge by seeing that you are behaving in a way that is appropriate for the circumstances and the gravity of going to court. I have been on a couple of occasions bullied. Bullying is not cool, no matter what age you are. It does leave an impression. I have an email from a colleague who was upset and said, "I'm not sure why you made a downright low-class attempt in your statements to pretend like I had violated some duty. I don't take kindly to anyone misrepresenting anything to the court." Well, there wasn't any misrepresentation. There was a share of the person's correspondence in a court record. And so not taking kindly to it prompted that strong reaction. And I do think that words are designed to both heal and harm. And in that case, the outcome ultimately ended in settlement, and it was an unpleasant moment. Try to create pleasant moments in your dealings. Sometimes people will cut you more slack. I have one more. And that one, once again, I had a difficult case with the reason it was difficult was there was a lack of civility in the interaction that came out of the blue from opposing counsel, who opened an email with this: "You are a complete waste of time." I think it's sad because the court didn't think I was a waste of time. My client didn't think I was a waste of time. And the insult did not result in any forward progress. In fact, because there was such animosity, the parties got down to talking with each other. And my client got exactly what she wanted, but only because the opposing party, her soon-to-be ex-husband, became very cooperative and didn't want to waste time. So those messages, I hope, will translate into something that will help you to understand that navigating choppy waters can often be done with a little bit more class and a little bit less of the pressure tactics that sometimes don't end well for the person who initiates them. Thanks so much for your time.
Yeah, those are very wise words. Thank you so much for sharing them with our audience today. Thank you.
Okay.
So as you can see, that in real life, you definitely have a situation where, especially from men to women, you'll see a lot of sort of base intimidation done, trying to, men trying to exert their strength over women as they've done in the workplace for many years. It sort of extends from that to women who are also attorneys, and it can be pretty tough, I think, from a woman's perspective, to try to stand up to a very aggressive male attorney. It's hard for men to stand up to aggressive male attorneys as well, and certainly it can go the other way too. Women can be intimidating towards men and uncivil to men as well. But as Joanne pointed out, what you really want to do is be able to not sink into that mud, and for yourself to rise above it, and to show that you're leading a positive example, even when the opposing counsel is not. Let's talk a little bit about the privacy level too. Is that an attorney should respect the privacy rights of parties and non-parties. For example, attorneys should not inquire into, attempt to threaten to use private facts concerning any party or other individuals for the purpose of gaining advantage in a case. And this guideline does not preclude inquiry into sensitive matters relevant to an issue, as long as the inquiry is pursued as narrowly as possible. Well, again, we're seeing situations where social media is complicating this sort of rule, where attorneys either purposely or by accident, are mostly purposely, are going and checking people's social media sites. They are going and talking with other people that they know are friends or associates of the plaintiff or the defendant in the case, as a way to dig up dirt on them and to try to use things that are private issues, but are things that you can discover through different means, not necessarily the most ethical means, as a way to use it as a weapon to strike against the other party and to hit them when they're most vulnerable. And also, as a challenge, is attorneys sometimes talking too much about their client's case on social media and coughing up facts that should remain private, or things that shouldn't be discussed, so the client wasn't expecting to be discussed through social media, but the attorney, or maybe even the attorney's staff, will let leak out on Facebook or Instagram or Twitter or something along those lines. That can be a problem too. So why is online civility different? We talked a little bit about this earlier, but now let's really focus on what makes working online different than being in person. And that is, physically, it is very different. And say, well, you know, it's all speech, it's all statements being made, but people act differently towards folks when they know they can be seen in person. They know when they are physically accountable for something like that. Not that someone would go over and punch somebody, but just looking into somebody's eyes in person is different than talking to somebody through, you know, WebEx or Zoom or something along those lines. It just is, you know, when you see them in person and there isn't the barrier of the computer between them, that's a big thing. And also, there's a lot to be said about body language and about how you act when you're being looked at by somebody. You know, your whole body, it's not just your head. It's not just something that you can control, lighting and all that other stuff to make you look a certain way. You can't control things that you do physically in person or the way that you act. And that can change how others perceive you. There's so much that's read into body language that actually really tells a huge story about how you're acting, and it's definitely different when you're dealing online. The anonymity, as we referred to, is really huge. That people can say things and then they can like, for instance, people can attack people online, create what's called burner accounts, which are fake accounts that are temporarily set up to harass or to give support. So in other words, I'm in an argument with somebody. Well, I create a couple burner accounts, and through these burner accounts, I say, yeah, Russ is right. Yeah, Russ is the one that's got the right point here. In other words, I'm agreeing with myself with 2 or 3 other burner accounts, or maybe more, to make it look like I've got a majority decision behind me, but it's really just me that's doing it. And it's so easy to pull off something like that. And it certainly can create a lot of problems and situations for people who are trying to combat that anonymity. And the fact that, you know, you don't get to see how people react, you don't get to see how their body language is online, as I mentioned, is part of that whole physically different thing. That you don't. There are certain expressions, there's certain things that people can gesture with their hands to make it see, to either emphasize a point or de-emphasize a point, or the quizzical look that somebody gets, they're not getting it, or even like the show of anger that people have is something that can be misinterpreted, or lack of interpretation can cause a problem. Obviously, one of the toughest things that creates probably more online civility disputes than anything else is sarcasm. It's not really well taken when it happens online. People don't always get sarcasm. There isn't quote unquote sarcasm font. And so a lot of sarcastic remarks that are done online can be misinterpreted and lead to some very bitter arguments. And as mentioned earlier, that there are language and cultural differences in phrasing that can occur. And so some people can be greatly offended by certain actions and behaviors that are online, where if you were doing it in person, it would either be explainable, or you would see that what you did created that offense, and you'd have some ability to backtrack or explain why that might not be what they think it is. But online, it's very easy to just, once you press send, to have that go over the internet and really upset some people by what you say, because it's not as sensitive or as it means something to somebody else you did not intend for it to. And then, of course, one of the toughest things about online civility situation is the reply to all button, which is for some people just too close to the reply button. And when you reply to all, you don't necessarily know, especially if co-counsel was on the response list, or outside counsel is on the response list, or maybe you're sending it to all members of the law firm, where you're saying somebody is a doofus for something they did in court. You didn't want them to hear that they said it. You can let that leak out. It's so easy with the touch of a button to send that out, and it's so difficult to try to retract it once it goes out. That ability to disseminate to others, which is a wonderful thing as far as mass communication goes, can certainly be a thing that can bite your civility in the butt as well. And so there's some negative results of online harassment that can be pretty serious, including physical threats. There have been situations where some people have gotten into online arguments, and one person, an ex-sailor, so upset at being referred to as a wimp and being coward and all that stuff, that he drove 2,000 miles across the country to the guy's house, where the guy was who he'd gotten into an argument with, and he set the house on fire. So certainly, you wouldn't want to see these things go this far, but the way people are these days, you just can't really predict how far they will take. Cyber stalking is one of the great problems that we have nowadays. And there's a term called doxing, with DOXXING, where a person first gets into an argument, then they go and they'll find out personal things about them based on doing a deep search on them, getting as much information as they can about them on the web, and then publishing those details, but in a harassing type fashion. And then it can turn into actual cyber stalking, where a person actually physically goes and looks and tries to find that person, or sends them different virus programs or other links that might cause them to harm their computer or their person. Then we see people really say that, okay, well, just what's printed publicly isn't enough. they want to steal that information. They want to steal more. They want to find out social security numbers. They want to find out credit card numbers. They want to, actually damage the credit, damage the electronic reputation of a particular person, or maybe even adopt their identity so they can cause, commit crimes in that person's name. And then, unfortunately, it really goes over the edge when you see online harassment turn into actual threats of threatening the job, threatening family, threatening business. I know people who run sites on Facebook, group pages on Facebook, and because people got into political arguments with them, they went and sent copies of those arguments to this person's job site to try to get them fired. And I myself have had people leave negative comments on my Yelp page and for my computer consulting services based on a political argument I had with them. They will make up and say, I hired this guy for this job and he was terrible and he was unprofessional and all this stuff. And I never worked for that person a day in my life. They will just go ahead and list that, put it on Yelp or put a negative review on Google reviews or so forth, just because they're bitter and they're angry people. They take outside of a political argument or something that happens online, and they want to make it happen as a problem in real life. So my advice that I have is that you don't want to work blue. I mean, if you can keep from swearing, if you can say the things that you would say if your grandmother was in the room, then that's a better way of managing yourself rather than saying, I want to get into a bar fight with somebody online and throw everything on the table out there. It's just, once you start swearing, once you start using epithets and that sort of thing, it never really goes anywhere. It just sinks and sinks and sinks, and it becomes pretty juvenile. And in the end, nobody really wins. Avoid talking about race unless you're prepared for controversy. I've never seen somebody really bring up racial issues without someone getting hot under the collar for one reason or another. And it's the same with religion too. I mean, some groups and some forums that you're in, they lend to that sort of conversation. And if everybody sort of agrees to ground rules, and there's moderators and people to take care of it when people get out of control, that's great. But some of the uncensored groups that get into, people will get really hot and they'll get really bothered, and that's where we get the stalkers and the people driving across country to light people's houses on fire. Now, keep in mind that all social media, they're not government run. They're privately owned, and they have terms of service, which means that you do not have an unlimited right to free speech when you're on a website and when you're on a social media source or any kind of a social group. There are terms that control what you can say, how you can say it, and you can have your account suspended or canceled if you refuse to follow those terms of service. Now, if it's an attorney, as we mentioned earlier, you have the option of going to the state bar they're in and to the disciplinary committee. They're really not going to probably act on just one or a couple things that are said online in a forum or something like that. I think it's something that you would, for an attorney, have to build a case of, where you're seeing repeated levels of harassment, of lack of civility, and things you can document, as we talked about, with witnesses, videotape, written documentation, that sort of thing. You combine it all into a cogent case, the state bar may be able to do something about putting that person in a place where they're certainly more civil, or they'll be fined. There are other professional organizations you can look into if the person is not an attorney. Say they're with dental association or doctors association, or even Better Business Bureau, or some other professional regulatory association that deals with their business. You could see that often those organizations will have a disciplinary committee or some way that you can make an ethical complaint against them. If it really gets out of control, then you can consider filing a restraining order in civil court against that person, and show that this sort of harassment goes beyond just one that you feel is them calling you names or so forth. Get a restraining order that can truly keep them from being able to approach you, or they would get arrested, or contacting you or your client without getting arrested. And then finally, if all these things lead to you getting fired, to you having damages in the sense of emotional, stressful damages, illness, not being able to communicate with your family decently, psychological problems, then you could look towards compiling all that information together and document it well enough. You could actually file a lawsuit against a civil suit for the damages that are caused by the unreasonable actions from the other party. It can be a difficult chore to get a case together along those lines, and proving damages in that instance is very difficult. But if you've got things that are really for sure something you can point to as a problem, and that you can document them, all of these things are made more cogent and more powerful if they're documented. Then you might be able, just by the threat of a lawsuit or filing a lawsuit, be able to see a significant character change by someone. Or say you're working with opposing counsel and you file a lawsuit on the extreme harassment that they've done. That opposing counsel may be fired by the firm, and they'll find you another counsel to work with, or maybe move the case to another law firm where there isn't that sort of culture of lack of civility. So I'd like to leave you with the attorney's pledge here in California that we have, which is, it said, I commit to these guidelines of civility and professionalism. I'll be guided by a sense of integrity, cooperation, and fair play. I will abstain from rude, disruptive, disrespectful, and abusive behavior. I'll act with dignity, decency, courtesy, and candor with opposing counsel, courts, and the public. Part of my responsibility for the fair administration of justice, I will inform my clients of this commitment, and in an effort to promote the responsible practice of law, I will encourage other attorneys to observe these guidelines. These are things that everyone can eventually agree to and act together on. The entire level of civility would increase, and wouldn't be so awful. People would be able to focus on the matters at hand instead of attacking the persons and the personalities of the people who are working the case. And that is my talk for today. Thank you very much for listening, and looking forward to speaking again with you soon.